All right. Welcome back. Welcome back. I hope you all had an excellent Thanksgiving for those of you in the US. For those of you not in the US, I hope you had a great Thursday a couple days ago. Um I was a little under the weather, so yeah, that's actually why I didn't stream last week or make videos last week, but I'm back. So, hello. Um for those of you who are new, I'm Joe. I'm an attorney licensed in the state of Utah. And so I often get asked in comments, especially when covering the frivolous litigation of delete laws, when is he going to be labeled a vexatious litigant and barred from bringing new cases, bringing new lawsuits? And the sad fact is, he's a long ways from that. So I've been sitting on this one for a while, but this is it's a good example of vexatious litigation, but this is like to an extreme that it's just it's unbelievable. But first, I've got to be a shill. So this is an unpaid advertisement. It's simply a very proud cousin shilling for his ridiculously talented cousin. Um, so my cousin, Sarah Hatch, has released her third children's book. It's available on Amazon. I'm going to try and remember to put the link in the description of this video, but this book is The Adventures of Hazel and Leo Racing in Arches. Um, I realize this looks like, at least the background arches, looks like photography. No, this is entirely hand drawn on her iPad. She is a ridiculously talented artist. So, yeah. And it's a children's book, aimed at younger children. But so basically, what I'm saying is, if you are a child, you shouldn't be watching this. Go away. If you have children, if you have grandchildren, if you know children, you should, support my cousin and get a good book for those children. And as I mentioned, it's her third book. She also has Hazel and Leo in the Ancient Redwoods being chased by dinosaurs, and Magic in the Smokies with unicorns. So, yeah. So that's my shill. Please support my cousin. She doesn't know I'm telling you to support her. So, you know, but on with the show. So the uh, the focus of today is Jonathan Lee Riches. Now, this is a like I said, this is all about vexatious litigation. We're going to go through his dockets and we're going to find some where, it's taken out right away because he's been declared a vexatious litigant. Or we'll find somewhere he is declared in that case as a vexatious litigant because he sues all over the country. So it takes time for each individual jurisdiction to label him as vexatious. But basically, what we have here is we have a scammer sitting in federal prison with nothing better to do with his time than file lawsuits. And they're all ridiculous. And as we go over them, you'll notice a pattern. He tries to be creative, but there's a pattern, and it yeah, he has nothing better to do, and he files them all in forma pauperis. So he basically says to the court, "Hey, look, I'm indigent, so I shouldn't have to pay the filing fee." But what that results in is the court reviews the complaint before it's even served. I don't know that he's ever actually served any of the defendants, but because the court is able to review it in its informa pauperis uh, review, it's able to say, this is frivolous, this is dismissed, no answer is needed. So, yeah. I think I may have seen a video on him before, but I found him again basically earlier this year when I first heard about the litigation between Brett Favre and Pat McAfee, the sports talking head. I went to Court Listener and searched, and this is the first case I found, was Jonathan Lee Rich's suing Brett Favre. And there's not much in the docket, at least on Court Listener. You all know I'm cheap. If I don't have to, I don't go on to Pacer. I just get the free stuff off of Court Listener. The order of dismissal is all we have on Court Listener for this. But that's good enough. We'll get plenty more. So this is the order of dismissal. So it's basically the magistrate judge articulating their findings. So plaintiff, a federal prisoner proceeding pro se, filed this pro se complaint under 42 USC section 1983 against Brett Favre. Now, we've seen lots of 1983 discussion before. That's civil action for deprivation of rights under color of law. Well, how on earth is Brett Favre acting under color of law, and how has he, deprived Jonathan Lee Riches of his constitutional rights? I don't know, but either way. So, a federal court must conduct a preliminary screening in any case in which a prisoner seeks redress from a governmental entity or officer or employee of a governmental entity. See 28 USC section 1915A. In its review, the court must identify any cognizable claims and dismiss any claims that are frivolous, malicious, fail to state a claim upon which relief may be granted, or seek monetary relief from a defendant who is immune from such relief. Pro se pleadings must, however, be liberally construed. To state a claim under 42 USC section 1983, a plaintiff must allege two essential elements. One, that a right secured by the Constitution or laws of the United States was violated. And two, that the alleged violation was committed by a person acting under the color of state law. Sections 1915A and 1915E2 accord judges the unusual power to pierce the veil of the complaint's factual allegations and dismiss as frivolous those claims whose factual contentions are clearly baseless. Examples are claims describing fantastic or delusional scenarios with which federal district judges are all too familiar. And that's citing Knightsky versus Williams, a Supreme Court case from 1989, which, if my memory serves me right, is it's cited in the Scofield versus Guillard case because Guillard, the TikTok psychic, her claims are fanciful or fantastic or delusional and not to be taken seriously. So good to see Knightsky versus Williams appear here as well. So, to pierce the veil of the complaint's factual allegations means that a court is not bound, as it usually is when making a determination based solely on the pleadings, to accept without question the truth of the plaintiff's allegations. A finding of factual frivolousness is appropriate when the facts alleged rise to the level of the irrational or the wholly incredible, whether or not there are judicially noticeable facts available to contradict them. Plaintiff here alleges that Brett Favre is conspiring with the federal government insofar as he pays income tax to the federal government, which is then used in part to fund the Federal Bureau of Prisons. Plaintiff further claims the federal government is engaged in a scheme to give Favre steroids and other performance enhancing drugs. Plaintiff alleges Favre has total disregard for federal inmates. He does not speak on behalf of federal inmates. He does not speak on behalf of federal inmates and their abuse or neglect. Plaintiff seeks $50 million from Favre and a restraining order. As plaintiff's allegations are clearly baseless, irrational, or wholly incredible, the complaint will be dismissed as frivolous under sections 1915A and 1915E2. For the foregoing reasons, this action is dismissed. And this was from December 2007. And this one was in the Northern District of California. So, and I intentionally opened with this filing instead of showing you the search on Court Listener for Jonathan Lee Riches. But get ready for those search results, because yikes. So here we have him suing Carrie Strug, the U.S. gymnastics Olympian hero from the 1996 Olympics. Here we have him suing someone, Scarfo. I don't know who Scarfo is. Let's look. Oh, it looks like it's probably someone associated with the mob. This being a federal inmate, his complaints are written in hand, by hand. So this is Jonathan Lee Riches versus Nicodemo S. Scarfo, aka Little Nicky Scarfo, Joseph Merlino, aka Skinny Joey, Milton Milan, Ralph Natale, John Stanfa, Robert F. Simone. And the complaint is for mafia harassment, asking for a temporary restraining order. Comes now the plaintiff, Jonathan Lee Riches. Copyright. He has some sovereign citizen tendencies. I didn't mention it yet, but you'll see some of them, especially like the copyright on his name. Names can't be copyrighted. But comes now plaintiff Jonathan Lee Riches, copyright, in pro se, moves this honorable court to issue an order for mob defendants named in this suit to respond. This is a harassment suit, and crimes pursuant to RICO, loan sharking, money laundering, shakedowns, extortion, identity theft, tax fraud, harassment, and terroristic threats. Plaintiff moves this honorable court to issue a temporary restraining order against defendants and defendants' mob connections, defendants' casinos. Plaintiff seeks $50 million collectively from defendants. Plaintiff prays for relief. This being handwritten, it's a little difficult to read, so. Defendants all plan to to move to Salters or something, South Carolina, around Federal Correctional Institute, Williamsburg, to start the LCN South Carolina chapter. Milton Milan is in secret plans with South Carolina Confederates to become FCI Williamsburg mayor. This is a coup that is going to take place November 4th, 2007, during midterm elections with the help of monks from Burma, who defendants paid off Union Teamster members, Local 666, Charleston, South Carolina, to box and ship monks carefully to the ports. 100,000 of them charging the gates of FCI Williamsburg with the help of Broad Street bullies from South Philly carrying Milton Milan on a golden chair like Pharaoh on November 10th, 2007. Once again, this handwriting is difficult to read, so I apologize. Defendants want to turn FCI Williamsburg into Scarfo casinos and use inmates as cocktail waitresses on December 1st, 2007. John Stanfo plans to use my eyeballs as rolling dice. Skinny Joey Merlino plans to eat me to gain weight on my birthday, December 27th. Defendant Robert F. Simone has been homeschooling me since February 25th, 2003, teaching me to write lawsuits. Well, Mr. Simone is not a very good law professor, in my opinion. Defendants forced me to sue DMX, aka Earl Simmons, in Maricopa County, Arizona, for mob corn on the cob ties. Baseball betting, I think, when Curt Schilling was a World Series pitcher in 2001. Defendants forced me to sue Florida State football coach Bobby Bowden on 4/18/07 in Leon County, Second Judicial Court, Tallahassee, because a lawsuit would distract Bobby Bowden from coaching while defendant Merlino has secret ties with Penn State coach Joe Paterno, his godfather, who is right behind Bobby Bowden all time in wins. A lawsuit would distract Bowden and Paterno would pass Bowden in wins. On 4/16/07, defendants threatened me with John Stanfo, who said he is going to transfer to FCI Williamsburg from USP Leavenworth if I don't sue Michael Vick in Allegheny County, Cumberland, Maryland, because Cumberland is a private CCN golf course that needs courthouse review since John Gotti's death. He'd be better served if he were putting this effort into writing fan fiction. Or, just fiction. Write a book. Try to sell it. You're putting your time into writing this nonsense, so you know my incredibly talented cousin, she doesn't spend her time frivolously litigating. She writes and illustrates her own books. Do that. On November 11th, 2007, defendants plan to hire Rocky Balboa to be my cellmate, sealing my cell door shut, giving Rocky brisk iced tea, and putting me on meat hook and stealing my brain and selling it to the Philadelphia Art Museum. I was the Billy Graham of Philly slums from 1995 to 2003. Defendants sent Linda Vizzi, special agent, uh, Philly FBI, after my identity theft. After my identity theft movements, defendants stalked me at Sesame Place on 6/23/07. Defendants tried to break my kneecaps when I went skiing at Blue Mountain to the Pocono 500, like they did to Sonny Bono, because Bono found out Cher was having an affair with Scarfo in 1988. Defendants plan to break into Mainline Models in King of Prussia, Pennsylvania, and take my copyrighted modeling pictures and sell them to KGB agents for rare 1943 vodka unopened, using my teeth as a corkscrew. 9/10/07, defendants tattooed Omerta on my forehead when they overfell. Uh, when they take over FCI Williamsburg, they plan to put candy and gold coins in my body and use a bat and tie me with a with a something tree like a piñata. Defendants plan to use the FCI Williamsburg grounds, uh, or the FCI Williamsburg Laundry Department to wash money. So money laundering. When I was a kid, I thought that's what money laundering was. You put it in the washing machine, make it clean. TRO, temporary restraining order. I'm scared defendants are going to bury me next to Jimmy Hoffa. Defendants made Steve Fawcett disappear because Fawcett owed NBA ref Tim Donaghy um, something. Um, yeah, I can't read that. But they owed NBA ref Tim Donaghy Philly mob money through Scores nightclub in New York. You can tell this was written about 15 years ago because that's when NBA ref Tim Donaghy was, outed as a cheater, as trying to fix games because he was gambling. And it was around that time that the multimillionaire adventurer Steve Fawcett went missing in his around the world balloon attempt. Defendants plan to bribe Philadelphia Eagles coach Andy Reid's son's judges to get both of them on probation. Andy Reid's with the Chiefs now, isn't he? So, yeah, this has been a while. I have nightmares that a mob of Sicily Italians and Fiats are going to execute me with Saddam's gallows. Defendants have my cell wiretapped by New England coach Bill Belichick and my room guarded or by Frody foot soldiers with Macta accents and Swiss guards with army knives ready to get Italian FCI Williamsburg inmates to stick me with prison butter knives. I need my medication. Signed, Jonathan Lee Rich's copyright. Well, that one was fun. And a lot of them look pretty similar to this. They're all equally outlandish. You can see why they get yeeted very quickly. But this is one of the rare ones in the search. This is a criminal case. So we don't need to look at that. Ooh, he sues the United States military in 2006 in the District of Wyoming. Okay, that helps. Blowing it up all the way. I should have done that on the other one. Complaint. This is a complaint under 42 U.S.C. Section 1983, civil rights violation by the Constitution and laws of the United States. Federal tort claims, violation of criminal law, including but not limited to terrorism, murder, treason, major fraud, wiretapping, extortion, torture, racketeering, civil rights, espionage, assault, conspiracy, genocide, war crimes, explosives, identity theft, obstruction of justice, piracy. R. Oh, I should have held off because right after piracy, arson, computer fraud, sabotage, perjury, criminal street gangs, concealment, false oaths, bribery, riots, slavery, robbery, malicious mischief, counterfeiting, search and seizures, injury to wildlife, sex abuse, rape, pornography, obscenity, kidnapping, stalking, liquor trafficking, psychiatric trauma, invasion, false information, threats to commit violent acts, malpractices, aggravations, nuisances, entrapments, mind manipulation, brutality, negligence, persecutions, and poisonings. Due to restrictions with typewriters and stationery, this complaint is handwritten with pencil. Comes now the plaintiff Jonathan Lee Rich's copyright, aka secured party, in pro se, moves this honorable court to issue an order for all defendants named in this suit to give a response. As plaintiff is claiming that his federal and state constitutional rights are being violated under the 1st, 2nd, 4th, 5th, 6th, 8th, 13th, and 14th of the Constitution. I'm surprised that he didn't claim a Third Amendment, that he's being quartered against his will, because, the Third Amendment restricts the government from quartering troops in private housing against people's will. Relief requested. Plaintiff seeks 78 cents back by gold and silver coins delivered by United Parcel Service, UPS, to Federal Correctional Institute, Williamsburg, Salters, South Carolina, collectively from defendants. Plaintiff seeks relief under the Federal Whistleblowing Act. Plaintiff also seeks preliminary injunction, temporary restraining order against defendants, defendants' spouses, and all military vehicles. Count 1. The U.S. military is in a vast conspiracy with Al-Qaeda for world control, New World Order. Joint Chief of Staff Peter Pace and all military generals joined alliance with Al-Qaeda on September 11, 2001. All military joined foreign alliance with the KGB, Colombian FARC, I think that's Sudan, but something Janjaweed rebels on October 5th, 2004. Count 2. The U.S. military has a secret base in Wyoming outside Yellowstone Park, a underground city, Central Command. The U.S. military is involved with the Trading with the Enemy Act, treason against this country, selling military secrets on eBay to foreign nations. Count 3. The U.S. military secret command centers in Wyoming is in violation of antitrust laws. Forming global domination, taking away Americans' right to bear arms. January 17th, 2002, U.S. Marines came to my residence at Holiday, Florida, and stole my 22 caliber rifle, 20 gauge Remington, multiple stun guns, military boot footprints, and a map of Wyoming secret operation center or something. It's cut off on the bottom of the page, so bad scan. Count 4. U.S. military killed millions of citizens. Evidence is footage on CNN, Fox News. They tried to poison me at FCI Bennettsville, South Carolina on June 18th, 2005, through the vents, chemical gases around the toilet. November 7th, 2004, I was at USP, not USCI or UCI. USP Coleman, Florida. The military tried to sniper me from a gun tower, shocking me with electronic impulses on November 9th, 2004. Count 5. U.S. military stole my identity on May 4th, 2004, using my credit to apply for a Sears card, $1,500 balance, and ExxonMobil gas card to finance their vehicles with fuel. Count 6. U.S. military plants RFID tags in American citizens. I witnessed this at a bird flu outbreak 12/18/03. Count 7. U.S. military created SARS virus 10/22/05. U.S. military sent computer viruses, hacker attacks 9/22/05. U.S. military set up secret concentration camps at Walmart parking lots starting around June 5th, 2001. This is amazing. This is amazing. Remember, this was filed in like 2006, long before President Obama was president. So, way before the Jade Helm conspiracy theory. That being that FEMA is going to set up concentration camps in Walmart and blah, blah, blah. I don't remember all the details because it was ridiculous. But this guy basically came up with Jade Helm a couple of years early. He's brilliant. U.S. military hires illegal immigrants on June 9th, 2003. Count 8. U.S. military violated trademark and copyright laws. They sold Jonathan Lee Rich's copyright t-shirts, mugs, shirts on college campuses. Recruiting stations still going on today. This started 8/13/03. Count 9. U.S. military is feeding me radioactive chemicals. 3/2/06. U.S. military is planning to nuke a U.S. city in the future. Chatter was picked up through the NSA. Count 10. U.S. military conspired with American highways to charge Americans use of toll roads with easy pass to track Americans. 7704. U.S. military conspired with OnStar to track all American vehicles. Log movement 6503. I've been insured. The military is sending radio waves. Oh, injured. Sorry. I've been injured. The U.S. military is sending radio waves to my brain as I write. I pray this is this count grants me relief. Respectfully submitted, Jonathan Lee Rich's copyright UCC 1 308. Did I mention he has sovereign citizen tendencies? And as I mentioned, this was 2006. So I believe that's like 2 months after President Obama became a U.S. senator. So, long before Jade Helm. And needless to say, it was dismissed 4 days later. But let's move on. He sued Jerome Kerviel. Once again, this shows that this was done about 15 years ago. Jerome Kerviel was the rogue trader with Societe Generale, the investment bank in Paris. He was a rogue trader, lost the bank $4.5 billion roughly. And this was huge news while I was doing my master's in finance. I knew I recognized the name, but I did have to look him up because it's been 15 years. He sued Dan Rather. He sued Randy Weaver. And so Kerviel was Central District of California. Dan Rather and Randy Weaver, Eastern District of California. He sued Santana Madera in the Southern District of California. He sued Eric Rudolph, the Atlanta Olympic bomber, in the Eastern District of California. He sued Ted Kaczynski in the Eastern District of California. Let's look at that complaint, shall we? So, Jonathan Lee Rich's copyright versus Theodore John Kaczynski. Complaint. Unibombing my life. Temporary restraining order. Comes now the plaintiff, Jonathan Lee Rich's copyright. In pro se, moves this honorable court to issue a TRO restraining order against defendant, his manuscript, and his log cabin. Plaintiff prays this honorable court for relief. 1. The defendant has been sending me electromagnetic encrypted threats to me through global solar flares on 9/17/07. Defendant has always had problems with me since I backed out of buying his Montana cabin in 1993. 2. Defendant told me he wants to unibomb my life because I won't return his manuscript that the Washington Post gave to me April 20th, 2004. Inside his manuscript has a secret letter regarding jurisdiction in the federal courts that defendant wants back. Title 18 of the Criminal Code, Public Law 80-772, is unconstitutional. The clerk of the House of Representatives, Jeff Trandall, refused to sign letters in response to requests for information. Finally, a letter was received from the clerk of the House, Trandall, in which he admitted that Public Law 80-772 was passed by the House in 1947, but was never voted on again by the House in 1948, even though the Senate amended it in 1948. Therefore, a different bill passed the House in 1947 than passed the Senate in 1948, rendering it unconstitutional and void. Further research showed approximately 9 constitutional flaws in the bill, any one of which rendered it void. When any of the argument was presented to the district courts, they tried to dodge the issue or deferred it to a magistrate who has no constitutional authority to avoid it. It appears that the issue of the validity of Title 18 of the Criminal Code and 18 USC 3231 is still in question. Why is the Unabomber after this? I compel this court to know if Title 18 USC 3231 is unconstitutional. 3. On Thursday, 9/13/07, defendant is rounding up all the Teds in the world to hurt me. Ted Kennedy, Ted Bundy, Ted Turner, Bill and Ted, Ted Nugent, Teddy Bears, Teddy Rumpskin. I think he means Teddy Ruxpin, the beloved 1980s toy. All notorious Teds are outside the FCI Williamsburg property waiting for my autopsy and to draw blood for the United Way. Restraining order. Plaintiff is afraid of Ted. Ted is a mysterious guy with magical powers and skeleton keys. I'm shaking. His face is scary. He has an evil look in his eye and beard. Plaintiff moves to block the Bureau of Prisons from transferring Ted Kaczynski to FCI Williamsburg. Plaintiff prays for relief. Respectfully submitted, Jonathan Lee Riches. Copyright 1-308. They're, yeah, and like I said, they all have a similar ring to them, but he always brings something new into them. Even if it's the same conspiracy, he brings something about why the person he's suing is famous into the lawsuit. And yes, there are page after page after page of search results. This one, I believe, is against Colonel Oliver North. Riches versus Simpson. Oh, it's O.J. Simpson and Yale Lance Gallanter. This one should be fun. Complaint. O.J. and his attorney are after me. Comes now the plaintiff, Jonathan Lee Riches, paranoid and frightened from defendants, in pro se, moving this honorable court to issue a TRO, temporary restraining order, against defendants plotting against my life. Plaintiff prays for relief. O.J. Simpson, ex-NFL running back, and Yale Gallanter, O.J.'s private attorney from Fort Lauderdale, Florida, are after my bones and brain. This conspiracy started back in July 2002. In July 2002, my co-defendant, Jason Michael Carpenter, hacked into America Online with a phishing and spamming program and took thousands of AOL customers' personal information. In January 2001, American Online contracted a company called Purchase Pro and CEO Charles E. Johnson to provide AOL with anti-hacking software, with Charles E. Johnson promising AOL that no one could hack into AOL's system using Purchase Pro software. In August 2002, American Online executives found out their system was hacked from the July incident. American Online contacted Purchase Pro to terminate the contract they had with America Online. At the time, Purchase Pro's counsel was Yale Gallanter, who defended Charles E. Johnson in previous cases. Purchase Pro's management told Yale Gallanter to find out who hacked into America Online and ruined their contract, and when Gallanter finds out who is responsible, Gallanter would send his paid hitman O.J. Simpson to hurt the hackers. February 25th, 2003, I was arrested by federal agents in Florida and charged with hacking into America Online in U.S. District Court in Houston. My Sixth Amendment rights are currently being violated under Booker and Fanfan, as my sentence was enhanced contrary to what I pled guilty to. Checking my plea bargain in transcripts. I was sentenced to 125 months in federal prison. Yale Gallanter found out I was responsible for the America Online attack through a CNN documentary. CNN presents How to Rob a Bank, which showed bank surveillance photos of me. Gallanter found out I'm currently at FCI Williamsburg and Salters, South Carolina. On 9/13/07, O.J. Simpson committed an armed robbery in Las Vegas. On 9/16/07, O.J. Simpson was arrested by the Las Vegas Police Department and sent to the Clark County Detention Center. On 9/18/07, O.J. Simpson contacted Yale Gallanter for help in representing O.J. and getting O.J. out of jail. During this conversation, Gallanter told O.J. that he will represent him with conditions. I wonder how Mr. Jonathan Lee Rich's copyright had access to this attorney-client privileged private conversation. He's making it up. That's how. He's making it up. Isn't that fun? Gallanter would arrange with the judge to release O.J. Simpson on a $125,000 bond. O.J. is to fly back to Fort Lauderdale to Gallanter's office. O.J. is then to purchase extra small black gloves, rent a Avis rent-a-car with a naked gun, and drive to FCI Williamsburg to hurt Mr. Riches for hacking into America Online, which was provided software from Purchase Pro, whose CEO was Charles E. Johnson, who hired Yale Gallanter for legal services. Temporary restraining order. Plaintiff moves this honorable court to issue a TRO against O.J. Simpson and Yale Gallanter. Yale is directing O.J. to come after me. I'm very worried and scared. I'm so nervous, even my handwriting is crooked. My pen is shaking. I can feel O.J. Simpson breathing down my neck. Plaintiff prays for relief. Respectfully submitted, Jonathan Lee Rich's copyright. No UCC in this one. Oh, and he actually did submit a motion for leave to proceed in form of papyrus on this one. Needless to say, it wasn't granted. Tanner Hall. I don't know who that is, so I'm not going to worry. Smirkonish, another Simpson in the first O.J. Simpson was in the Southern District of Florida. This one's in the District of Nevada. and it's completely different. But let's change it up and not read a second longer OJ one. Metter, don't know who that is. Riches versus Perlman, Central District of Illinois. Ooh, and this is a writ petition for writ of habeas corpus against. Oh, this. Yeah, this might be a somewhat legitimate petition for a writ of habeas corpus, saying they violated his due process um, and froze his inmate trust account and stuff. So that might have been slightly not frivolous, but either way. Riches versus McBride. Let's see who McBride is. Justin McBride, DBA Professional Bull Riders World Finals, PBR. This one is very short. So, complaint, bull riding fraud. Comes now, the plaintiff, Jonathan Lee Riches, copyright, in pro se, under 42 U.S.C. Section 1983, and under Federal Rules of Civil Procedure, Rule 64, the return of the bull riding championship belt because of cheating. McBride has been harassing me at FCI Williamsburg. I knew McBride before I went to prison for identity theft. I used stolen credit cards to pay for bull riding school for McBride so he can compete professionally. During the 2007 Bull Riders World Finals, McBride's outfit was bought with stolen credit from Wrangler. I gave McBride a Capital One no hassle credit card to buy Stetson cologne. Now McBride threatens to stampede me, sending the bull stock market after me. McBride has ties with the Chicago Bulls. FCI Williamsburg serves me nothing but bull meat, injected with steroids. I have a bright red prison jumpsuit. I'm a target from defendant and his poultry. Jonathan Lee Riches, copyright. Yeah. Uh, Riches versus Abagnale. Don't know how to pronounce it, but that's Frank Abagnale. He was, can't remember if he was the ex mobster or the federal agent undercover as a mobster. I think he was the ex mobster. And that's Western District of Virginia. Ooh, this one should be fun. Riches versus Polizzi in the District of Oregon. Why the District of Oregon instead of the District of New Jersey? I don't know. But let's find out. This is Jonathan Lee Riches, aka Jared Lee Loeffner, aka Ronnie Ortiz Magro, plaintiff, versus Nicole Snooky Polizzi, DBA Jersey Shore, Jenny J. Wow Farley, and Mike the Situation Sorrentino. Preliminary injunction, temporary restraining order, and 28 USC 1331. My name is Jonathan Lee Riches, and I face imminent danger and bodily harm from Snooky, JWoww, and the Situation at the Jersey Shore on South Beach in front of Oregon Ducks. Defendants chased me along the Lewis and Clark Trail, and defendants forced me to drink shots of rum with them on Gilligan's Island, and I passed out next to Natalie Holloway, then missed my probation appointment, and I violated, then went to prison. Defendants were responsible. Then I went to school at Eastside High, and Snooky and Joe Clark locked me in a locker with chains with the fat black kid on juice, and I personally saw Snooky and JWoww sleep with every kid on The Lord of the Flies, and I missed out on a golden opportunity to be the first Jewish guy on Jersey Shore. I was in line at the MTV tryouts, and Mike, the situation, was in back of me and gave me laxatives in my Diet Pepsi and put ants in my pants. And in 5 minutes, I had a jock itch and ran out of line and changed my diapers in um and still denied a spot on Jersey Shore, but promised a role in Alcatraz, and then the warden took my lawsuits and I cut off my right hand in front of Clint Eastwood. But I swear to this on the Bible with my left hand. Then I became Captain Cook, I think Captain Cook, and Snooky was escorting for Somali pirates, and JWoww lap danced Johnny Depp on the Pirates of the Caribbean. I was behind them. JWoww was secretly married to Chris Farley, and Snooky ate candy with John Candy on Coney Island in front of Daryl Hannah and Hannah Storm, and Hurricane Katrina slept with Sorrentino on Jekyll Island for Federal Reserve notes, and Snooky rode the creature of the Black Lagoon. Snooky stuck my head in a hermit crab shell, and JWoww put a restraining order against the Karate Kid. That's why he moved. Snooky ate an entire jar of my Mott's applesauce. Then she went to Red Lobster with my Long John Silver's gift certificates, and Snooky stuffed jumbo shrimp in her bra and took dinner rolls, and then JWoww has been sleeping with Governor Christie at Graceland's mansion, and Snooky pole danced for Springsteen's E Street Band. Snooky forced me to print her, uh, paint her nude on the Titanic, and the defendants all lost their virginity in Cherry Hill, New Jersey, and stole Cal Ripken's balls in Camden, and I personally saw Snooky in my history books as a makeshift raft for George Washington floated on top of her across the Delaware. Then Mike, the situation, bench pressed me against my will in front of his surfer buddies. Snooky secretly helped Tony Soprano bury Jimmy Hoffa in the Pine Barrens, and Harriet Tubman's Underground Railroad, and Donald Trump got Snooky pregnant at the Tropicana. Snooky was on a flotilla giving Hamas hams, and I got seasick. JWoww sunk my battleship, and Sorrentino was a ship captain on the USS Cole. Don't ask, don't tell. Because Sorrentino had sex on the beach with the Beach Boys and Pish. I think that's probably meant to be fish. Defendants instructed the CIA to waterboard me, and Snooky flashed Mormons on the Great Salt Lakes nudist colony. I saw Snooky give Alka-Seltzer to seagulls. Sorrentino stole my wallet and used funds to buy steroids from Barry Bonds. And Snooky got a boob job on Christina Applegate's credit. And one crazy summer, defendants and Demi Moore buried me in sand under a fat man eating beans. And Snooky personally uh, scouted out missing kids on milk cartons for the Lost Boys. Snooky gave me crabs. JWoww listens to Coast with George Knorr, then claims global warming and said she saw Swamp Thing assault me with seaweed, which is slander. Snooky put a prison hit out on my life with Jaws, Snorks, Anaconda, Quicksand as hitmen in the 1980s. Snooky hypodermic needles pricked me at Ocean City, and JWoww and Snooky slept with Naughty by Nature in Orange. I seek restraining orders against the Jersey Shore broadcasting shutdown of all natural beaches. The defendant's actions scare me, offend me, which caused me anxiety attack in my solitary cell at the Federal Medical Center in Lexington, Kentucky. I plan to move to an offshore tax haven when I get out of prison. See you later. Respectfully submitted, Jonathan Lee Riches. Hey, this one's not even copyrighted. That one was fun. Oh, and he mentioned he he did an AKA of himself as Jared Lee Loughner. But we click to the next page and he sues Jared Lee Loughner. Then, and that's in the District of Arizona. In the Western District of Kentucky, he sues Jones. That's Mother Jones, the Jesus, he's got an entire page of defendants. And a quick scan, I don't recognize any of them, although I notice Richter and Hampton LLP, that I believe is a law firm. So Riches versus DEFCON in the District of Nevada, Riches versus Carr in the Western District of Arkansas, Riches versus FEMA in the Middle District of Pennsylvania, Riches versus Marsalis, also in Pennsylvania, Riches versus Winfrey, Northern District of Illinois. Shall we see what he has against Oprah? All right. Jonathan Lee Riches, copyright versus Oprah Winfrey and Harpo Productions, Inc. Civil complaint. Violation of my 6th and 8th Amendment rights. Temporary restraining order. Comes now the plaintiff, Jonathan Lee Riches, in pro se, moves this honorable court to issue an order for defendants in this suit to respond. This suit is civil rights and constitutional violations defendants committed and crimes pursuant to kidnapping, conspiracy, neglect, tax fraud, torture, crimes against humanity, aiding and abetting, abuse, cruel and unusual punishment, deliberate indifference, treason, and harassment. Plaintiff moves this honorable court to issue emergency restraining order against defendants forbidding any direct or indirect contact with plaintiff and plaintiff's copyrighted name. Plaintiff seeks $7.5 million from defendants. Plaintiff requests a jury trial. Plaintiff prays for relief. Defendants, Oprah Winfrey is a talk show host for the Oprah Winfrey Show. Harpo Productions, Inc. is the company that runs the show. Plaintiff, Jonathan Lee Riches, copyright, is a freedom fighter, political prisoner, serving a illegal sentence of 125 months in federal prison for identity theft. Plaintiff is currently at FCI Williamsburg in Salters, South Carolina. Defendants have been in a vast conspiracy every day since February 25th, 2003. Defendants, through direct and indirect financial and logistical support, have been kidnapping me and inflicting psychological torture on me since February 25th, 2003. Every day, 24 hours a day, since February 25th, 2003, defendants are purposely inflicting a deliberate indifference on my health, mind, my body, and soul. Defendants are terrorists planning on kidnapping more innocent Americans and holding them hostage against their will. Ever since February 25th, 2003, defendants have been paying state and federal taxes. Defendants pay federal tax on fuel, telecommunications tax, property taxes, federal income taxes. Defendants' tax money supports and contributes to my current illegal incarceration. Defendants' tax money goes to the federal government, who distributes the funds, to the Department of Justice and the Bureau of Prisons. The Bureau of Prisons use defendants' tax-paying money to construct prisons, including FCI Williamsburg, where I'm being held hostage. Defendants' tax-paying money pays the salary of prison administration, prison correctional officers, cache of weapons, patrol vehicles, holding cells, barbed wire. I've been held hostage and kidnapped and tortured every day since February 25th, 2003 by Bureau of Prisons administration and correctional officers who are being financed by the defendants. Defendants are paying for this operation. Defendants' tax paying supports my oppression. You get it? Oppression. Yeah, I'm gonna not seek a career in stand up. Defendants are violating my Sixth Amendment rights. Defendants are financing and supporting the violation of my Sixth Amendment rights through them paying taxes. My criminal case is out of the Southern District of Texas. I was enhanced and sentenced to millions of dollars of fraud losses under yeah, I can't. 2B1 2.B whatever. Relevant conduct that was not presented in my federal indictment. A jury did not find me guilty of or admitted to in my plea agreement. This is a clear Sixth Amendment violation under Blakely versus Washington and US v. Booker slash FanFan. My sentencing transcript and plea bargain hearing transcript can be obtained through the Southern District of Texas, or I can submit upon request. During my plea bargain hearing, I admitted to and pled guilty to fraudulent $425 wire transfer via Western Union. I did not plead guilty to any other dollar amount, or was any other dollar amount mentioned during my plea agreement. 6 months later, the government and defendants, through their tax-paying support, makes a PSR, pre-sentence report, determination that I was a ringleader in an interstate identity theft ring with fraud losses in the millions. A Sixth Amendment violation that defendants financially support. I was sentenced as if I took millions of dollars to 125 months in federal prison. Defendants' tax-paying supported this violation of my Sixth Amendment rights. Defendants' tax-paying goes to the federal salary of U.S. District Judge Melinda Harmon, AUSA J. Heilman, U.S. Probation Officer Kimberly Jones, and FBI Special Agent Shauna A. Dunlap's violation of my Sixth Amendment rights. In now being kidnapped through defendants' financial support, I will be shot and killed if I try to leave FCI Williamsburg. Defendants' taxpaying pays federal correctional officers with guns and armored vehicles to kill me if I leave. This Sixth Amendment violation that defendants financially supports has caused me everlasting duress in numerous ways. I suffer schizophrenia now because of defendants' deliberate indifference. I suffer emotional scarring, emotional pain, and suffering because of defendants' financial support of the violation of my Sixth Amendment rights. Defendants have been violating my Eighth Amendment rights to cruel and unusual punishment, deliberate indifference every day, every hour, every minute since February 25th, 2003. Defendants taxpaying to Bureau of Prisons employees, including the warden at FCI Williamsburg. Defendants are paying for the warden's salary. Under the defendant's direct orders, they told prison officials to kidnap me and hold me in a tiny cell at night, force me to sleep in a cell with another stranger, force me to stand at 4 p.m. every day for count. Even sorry, if I don't comply, defendants told officials to hog tie me and throw me into a dark hole. Defendants are not feeding me properly. Defendants' taxpaying feeds me chemically induced foods. Laced with pesticides, aspartame, tainted beef and poultry, spoiled milk, fluoride in the water system. I've suffered massive weight loss because of defendants' financial support. I currently weigh 125 pounds and stand at 5 feet 10 inches. I have photos I can submit upon request. Defendants told the warden to take all fruits out of the prison. Defendants told the warden to keep me over 500 miles away from my family, causing me everyday emotional sadness and neglect. Defendants financially support no parole in the federal system. Defendants are in a conspiracy with the prison phone system to keep phone rates marked up and overinflated. This is so defendants can receive tax breaks and kickbacks from the BOP. Defendants have not allowed me to see a dentist in 53 months. Defendants' taxpaying supports correctional guards and administration staff to verbally, physically, and emotionally abuse me every day. I have forever brain damage from the defendants violating my Sixth and Eighth Amendment rights together. I will never be the same from this illegal kidnapping. Restraining order. Defendants are committing the Stockholm Syndrome every day on my life. Through the television media, every day I see defendants smiling, I think, trying to divert the kidnapping through entertainment. It works on other inmates, but not me. Plaintiff moves this honorable court to issue a restraining order against defendants contributing to my kidnapping, violating my Sixth and Eighth Amendment rights. Moves this court to forbid defendants from doing financial dealings with kidnappers. Moves this court to restrain defendants from paying taxes that support my constitutional violations. Plaintiff moves this honorable court to issue an order for defendants in this suit to respond. Respectfully submitted, Jonathan Lee Riches. Copyright. So, if I were Oprah, I actually would have responded. I would have said, "You know what, court? I agree. I would respectfully like a restraining order enjoining me from paying federal taxes." That would be great. You know, it's a win-win. The Jonathan Lee Riches gets the prisons even more underfunded, makes conditions worse for himself, and Oprah doesn't have to pay taxes. Win-win, wouldn't you say? Next, he sues Chickies and Pete's in Pennsylvania, Libby in New Hampshire, Underwood in the Eastern District of Oklahoma, Katie Couric in the Eastern District of California, Cowart in the Eastern District of California, Don Imus in the District of New Mexico. Oh, the Branch Davidians in the Western District of Texas. Daniel Day-Lewis in the Eastern District of California. The World Money Show in the Middle District of Pennsylvania. The Warden at FCI Williamsburg in the District of South Carolina. The Ohio State Buckeyes in the Eastern District of California. Louisiana State University in the Eastern District of California. The U.S. Postal Service in the Eastern District of Pennsylvania. Omaha West Roads Mall in the Eastern District of California. Termini Bros Bakery in California. Federal Medical Center, Lexington, Eastern District of Kentucky. He sues the No Child Left Behind Act in the Eastern District of California. Dick Clark, New Year Rockin' Eve, 2008, in the Eastern District of California. Kosala, District of South Carolina. Secaucus in South Carolina. So yeah, I don't know any of those. Haynes Brands in the District of Southern California. Okay. And I'm going to click on this one for a reason. Not clicking on the complaint because I don't want to pay for it, but he sued Levi Leipheimer and FCI Williamsburg, Ryan's Family of Steakhouses and Bureau of Prisons, Amtrak, DBA, National Railroad Passenger Corporation, and FCI Williamsburg, Shoney's, Sizzler, Hard Rock Cafe. So, yeah. Whole bunch, multi pages. So this is the court's ruling dismissing, but I believe this is an important one. So the plaintiff, Jonathan Lee Riches, is a federal inmate at FCI Williamsburg, proceeding pro se. Footnote 1. Riches is a well-known litigator in federal courts, having filed more than 1,000 actions in various federal district and appellate courts since 2006. See U.S. Party Case Index, PACER, showing 1,793 cases filed as of April 21st, 2008. Since December 2007, plaintiff has filed 568 cases, including the present actions with this court. Pro se review. A review has been made of the pro se pleadings pursuant to the Prison Litigation Reform Act, PRLA, footnote 3. Pursuant to the provisions of 28 U.S.C. section 636B1B and local rule 73.02B2D, DSC, the undersigned is authorized to review such complaints for relief and submit findings and recommendations to the district court, because this is a magistrate. This review has also been conducted in light of the following precedents: Denton versus Hernandez, Knightsky versus Williams, we've mentioned that one before, Haynes versus Kerner, Nassim versus Warden, Maryland House of Corrections, and Todd versus Baskerville. This court is required to liberally construe pro se documents. holding them to a less stringent standard than those drafted by attorneys. Even under this less stringent standard, however, the pro se complaints are subject to summary dismissal. The mandated liberal construction afforded to pro se pleadings means that if the court can reasonably read the pleadings to state a valid claim on which relief could prevail, it should do so. But a district court may not rewrite a complaint to include claims that were never presented, or construct the plaintiff's legal arguments for him, or conjure up questions never squarely presented to the court. The requirement of liberal construction does not mean that the court can ignore a clear failure in the pleadings to allege facts which set forth a claim cognizable in federal district court. Discussion. The plaintiff's claims in the above listed cases are subject to summary dismissal under the three strikes rule of the Prison Litigation Reform Act. This rule, codified at USC section 1915G, provides, in no event shall a prisoner bring a civil action or appeal a judgment in a civil action or proceeding under this section if the prisoner has, on 3 or more prior occasions, while incarcerated or detained in any facility, brought an action or appeal in a court of the United States that was dismissed on the grounds that it is frivolous, malicious, or fails to state a claim upon which relief may be granted, unless the prisoner is under imminent danger of serious physical injury. Congress enacted the three strikes rule to bar prisoners, such as the plaintiff, who have filed prior frivolous litigation in a federal court, from pursuing certain types of federal civil rights litigation. See Senate Select Committee on Presidential Campaign Activities versus Nixon, District of D.C. 73. When it comes to the jurisdiction of the federal courts, truly, to paraphrase the scripture, the Congress giveth and the Congress taketh away. This court may take judicial notice that the plaintiff has previously filed at least 3 cases dismissed and deemed a strike under the section 1915G by this court. Footnote 4. Plaintiff has filed more than 3 prior frivolous cases in this court since 2006, and such previous filings have been duly noted in reports and recommendations and/or orders of this court in the following cases, with the case numbers. And you'll notice that that's just discussing in this court specifically. So, and C, Aloe Cream Laboratories Inc. versus Francine Co., Fifth Circuit 1970, which says the court may take judicial notice of its own records. And see also Mann versus People First National Bank and Trust, Fourth Circuit 1954, approving a trial court's taking judicial notice of proceedings had before it in prior suit with the same parties. In light of the plaintiff's prior strikes, he cannot proceed with the instant complaints unless, 1, his claim satisfies the exception for imminent physical harm provided by the 3 strikes rule, or 2, he pays the full filing fee. I don't know why I didn't maximize this at the start. In order to invoke the imminent danger exception of the Section 1985G, an inmate must make specific fact allegations of ongoing serious injury or of a pattern of misconduct evidencing the likelihood of imminent serious physical injury. That's Johnson versus Warner, a slip opinion from the Fourth Circuit in 2006, which quoted Martin versus Shelton, Eighth Circuit 2003. In addition, fact allegations that are remote, speculative, or hypothetical do not rise to the level of imminent danger. See Welch versus Selsky, Northern District of New York, 2008, which says the imminent danger an inmate faces, moreover, must be real and not merely speculative or hypothetical. See also White versus State of Colorado, 10th Circuit, 1998, which says vague or conclusory assertions of harm fail to raise a credible allegation of imminent danger. Congress intended that the danger must exist at the time the complaint is filed. Therefore, the imminent danger exception does not apply to harms that have already occurred. Um, Obviously, aware of the potential three strikes bar to his claims, plaintiff includes the term imminent danger in many of the instant complaints. Footnote 5. Plaintiff further attempts to circumvent the three strikes rule by styling many of his actions as 28 USC section 2241 habeas corpus or 28 USC section 2241 Bivens actions. However, as these actions seek relief from a variety of allegedly unconstitutional prison conditions, they have been construed as actions brought pursuant to 42 USC section 1983. Plaintiff also alleges that he has received threats from or been mistreated by many of the defendants. Although plaintiff uses the term imminent danger repeatedly, the instant pleadings fail to provide any specific fact allegations concerning an ongoing serious injury suffered by the plaintiff or the likelihood of imminent serious physical injury to the plaintiff. Plaintiff's vague assertions regarding the receipt of threats from many of the defendants are insufficient to raise a credible claim of imminent danger. And the imminent danger exception does not apply to plaintiff's claims regarding past mistreatment. As the instant complaints do not invoke the imminent danger exception to Section 1915G, plaintiff is barred by the three strikes rule from proceeding with the above referenced cases, unless the filing fees are paid. Plaintiff is hereby given a period of 10 days from the date of service of this report and recommendation to pay the $350 filing fee for each of the 69 instant cases. The time calculation of this 10-day period excludes weekends and holidays and provides for an additional 3 days for payment of the filing fees by mail. Imposition of sanctions. Plaintiff has demonstrated a propensity to file frivolous lawsuits in this court. To date, plaintiff has filed at least 34 cases which have been summarily dismissed by the court due to frivolity, maliciousness, or failure to state a claim upon which relief may be granted. Footnote 6. The case numbers. In addition, plaintiff has filed at least 82 cases since December of 2007, which have been dismissed for lack of prosecution, failure to comply with an order of this court. Footnote 7. More case numbers, and footnote 8 will be too, so we won't scroll down when we get to it. 93 additional cases have been dismissed due to the three strikes rule of USC section 1915G. Plaintiff has been warned in 112 cases that sanctions could be imposed, which would place restrictions on plaintiff's ability to file future cases in this court if he, 1, continued to submit cases which he failed to pursue and prosecute, or 2, continued to file cases which failed to state a claim upon which relief may be granted or were deemed frivolous or malicious. Despite this admonishment, plaintiff has continued to file cases which are frivolous, fail to state a claim upon which relief may be granted, or are barred due to the three strikes rule. Thus, it appears plaintiff will continue to waste this court's precious judicial resources unless restrictions are placed on plaintiff's future submissions. This court has the authority to order a pre-filing injunction or other appropriate sanction against vexation litigants. And that's Cromer versus Kraft Foods, 4th Circuit 2004. See also Thomas versus Fulton, sub opinion 4th Circuit, which says a pre-filing injunction must be narrowly tailored to fit the circumstances of the case. And Saphir versus United States Lines, 2nd Circuit, 1986. 5 factors for the court to consider before imposing order of pre-filing review. Flint versus Haynes, 4th Circuit, 1981. where they joined other courts in approving pre-filing review of complaints brought by prisoners with a history of litigiousness. And Graham versus Riddle, Fourth Circuit. So the sanctions which the court may consider include, but are not limited to: 1. Denial of proceeding without prepayment of the filing fee; 2. The imposition of a filing injunction order placing restrictions on the types of cases plaintiff may file and the manner in which they must be submitted; 3. Monetary sanctions that will have to be satisfied before any further filings may be made; 4. Dismissal of any action; 5. Entry of an order of contempt of court; and 6. Any and all other forms of sanctions available to the court under Rule 11 of the Federal Rules of Civil Procedure. Overly litigious, malicious, and/or vexatious individuals, such as the plaintiff, place a burden on the judicial system and divert judicial resources from other pending litigation. A court must balance between ensuring access to the courts and controlling already overburdened books. Due to plaintiffs' extensive history of frivolous filings, other district courts have placed various restrictions on plaintiffs' ability to file future complaints. See N. Ray Jonathan Lee Riches from the Northern District of Georgia in 2008, which required plaintiff to obtain leave of the court before filing any new lawsuit. Riches versus Stanley Allen Acuff, District of Maryland in 2008, finding it appropriate to issue a pre-filing injunctive standing order. Riches versus Lemony Snicket, Northern District of West Virginia, 2008, that the clerk be instructed not to file any further actions received from Jonathan Lee Riches without the express written order of a judge of this court. Riches versus Giambi, Northern District of California, 2008, requiring payment of the filing fee. Riches versus Simpson, Middle District of Florida, 2007, requiring plaintiff to pay the full filing fee. Plaintiff has filed 568 complaints in this court since December of 2007, setting forth frivolous, nonsensical, and largely improbable claims against a litany of defendants. Plaintiff has clearly demonstrated that he is a vexatious and abusive litigant in this court. Given the numerous warnings regarding the imposition of possible sanctions that plaintiff has already received and ignored, it appears that no alternative to a pre-filing injunction will protect the court. Therefore, it is recommended that the court issue a filing injunction against the plaintiff. The filing injunction would direct the clerk of court to return any civil action submitted to this court by the plaintiff unfiled unless the following requirements are met: payment of the full statutory filing fee, currently $350, $402 now, at the time any new civil case is submitted for filing; or 2. Submission of a petition to the clerk of court seeking leave to file a new civil case. The petition must contain all of the following information: A. The name of the defendants that the plaintiff intends to sue pro se without payment of the filing fee. B. For each defendant named, that defendant's domicile. C. For any defendant whose domicile is outside of this district, a statement explaining why this court would enjoy personal jurisdiction over that defendant and why venue for plaintiff's claim is proper in this court. D. A brief summary setting forth with specificity what each defendant has done to cause plaintiff injury. E. A statement setting forth the legal theory pursuant to which plaintiff believes he is entitled to relief. F. A statement under penalty of perjury and subject to all sanctions available to the court for untrue statements that, to the best of the plaintiff's knowledge, 1. The information contained in the petition is true and correct. 2. The legal arguments are not frivolous or made in bad faith. 3. The proposed case does not involve any of the same factual or legal matters as were/are involved in any of plaintiff's previously disposed / currently pending civil actions in this court. And 4, that plaintiff will comply with the local rules of this court and with the federal rules of civil procedure. Then moving back to the lettered list, G, the petition for leave to file a new complaint must be signed by plaintiff in plaintiff's full legal name. The following statement must appear above plaintiff's signature. This document and all statements contained herein or attached hereto are submitted under penalty of perjury and subject to all available court-imposed sanctions for untruthfulness, frivolity, and or vexatiousness. H, an official notary public seal and signature in proper legal form attesting to the validity of plaintiff's signature must be affixed to the signature page of plaintiff's petition. I don't think that one's actually needed. Like, I don't think it accomplishes anything, but if the court wants it, the court can mandate it. I, the following documents must be attached to the petition for leave to file a new civil action. 1, a complete signed original of the pleading that plaintiff wishes to file as a new case pro se and without payment of the filing fee. 2, a fully completed and signed Form AO-240 application to proceed without payment of fees and affidavit. 3, a fully completed financial certificate. And 4, fully completed court-approved service of process forms, summons, and Form USM-285 for each defendant or respondent named in the pleading. Recommendation: should plaintiff fail to pay the filing fees as directed above, it is recommended that the complaints be dismissed under the three strikes rule of 28 U.S.C. Section 1915G. It is further recommended that the United States District Judge assigned to this case consider the entry of the above sanctions against plaintiff. The plaintiff's attention is directed to the important notice on the next page. And that's signed William M. Cato, United States Magistrate Judge, Greenville, South Carolina. And this is the notice of right to file objections to the report, so we don't need to worry about that. So that's what it looks like when someone is declared a vexatious litigant. That is specifically under the vexatious litigant rule for federal prisoners. I think there are places in other cases where it might have the more general vexatious litigant that applies to everyone, not just federal prisoners, but that's basically what it's going to look like. So with that, I think we've accomplished what we need to accomplish for today. But one more shameless plug. You know, this is going up on Cyber Monday. Go show my cousin Sarah some love. Buy her books. They're excellent. I don't have the new one yet, Racing in Arches. I have the other two upstairs. So, you know, I practice what I preach. There, I mean, just look at that. Look at that cover. How I seriously thought that was a photograph. She's so talented. So, and other than that, please like, share, subscribe, do all the YouTubey things, and I will see you soon for the next one. Thanks for joining me. Bye-bye.